Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be serial tenants, rent thieves.
Sorry, but I'm not paying the rent and I'm not moving. I prey on unsuspecting landlords. The laws in California are all on my side. I intend to stay here rent-free for at least 6 months, and there is nothing you can do about it. I will get a free attorney, and I will request a jury trial. At the end of the case, the court record will be sealed, and I get to do this all over again. I love California.
Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening live, the name of that song was Hey There, Delilah, and it was performed by Plain White T's. And the inside story about that was that the song was inspired by a woman by the name of Delilah DiCrescenzo, and she was a nationally ranked long-distance runner from New York. And she met Tom Higginson, who was the lead singer of Plain White T's. And Tom was so infatuated with her that he told her that he was going to write a song about her. And the song is about, of course, an imagined long-distance romance inspired by his admiration of her. Now, Delilah was very flattered, but also felt awkward because fans assumed that she and Tom were going together. But the truth was they never actually dated. The song was released in 2006 and became the #1 hit on the Billboard 100 in the year 2007. Just a beautiful song. Okay, let's talk about the show format. As you know, we have an opening topic, and then after the opening topic, I will open it up to questions and answers for those people that are in the Zoom meeting room. If you are in the Zoom meeting room, you can talk to me by electronically raising your hand. I will call on you in the order that your hand was raised, so you can do that now if you'd like, so you'll be sure that your question will get answered. Also, I would ask that if you are talking to me, leave your camera on because it's much more enjoyable if the audience and I can see each other. It makes it much more enjoyable. If you are watching on YouTube, please hit that like button and subscribe to the channel because it really does help me out. Also, if you do want to ask a question and you're in YouTube, please just leave it in the comments and I promise you I will get to your questions. If you did want to join the Zoom meeting every Saturday at 3 p.m., the easiest way to do it would be to go to my website, evict123.com. That's EVICT 123.com. And by doing so, you'll get the credentials. So if you don't want to watch it on YouTube and you want to actually ask me questions live, then just join the Zoom meeting every Saturday at 3 p.m. Okay. Let's now talk about the opening topic. And what is that opening topic? And that is serial tenants, rent thieves. Serial tenant, rent thieves. So what is a serial tenant? I'm going to read you a definition. A serial tenant is an individual who repeatedly engages in behaviors that violates lease agreements, such as non-payment of rent, causing property damage, or exploiting legal loopholes and eviction processes to prolong their stay without fulfilling any of their obligations. They often move from one rental property to another, leaving a trail of unpaid rent, damages, and legal costs for landlords. This is often aided by the laws which allow tenants to have their eviction records sealed, making it difficult for future landlords to determine whether they've been evicted before. So I want to talk about one case in particular. And this case, of course, made the news, and we were the attorneys of record. And that case dealt with a tenant by the name of Ellie Mae McNulty. Ellie Mae McNulty. I've literally evicted her several times. And what she does is she preys upon landlords in the wonderful city of Malibu. So let's talk about the cases that I had against her. The first case was back in October 5th of 2016. She rented a house on Malibu Highway, excuse me, on Mulholland Highway in Malibu. She signed a 1-year lease for $3,000. That was on October 5th of 2016. Well, on December 5th of 2015, 2 months later, she stopped paying the rent. And of course, we were eventually hired, and we did actually go through an entire eviction case, and she was evicted on April 17th, 2017, with a judgment against her for $11,350, which to this date has not been collectible. So what does our little friend Ellie Mae McNulty do next? Well, in early 2018, she moved to Cross Creek Road, again in Malibu. Now, the owner lived in a house, but he had a trailer on the property and he rented her the trailer. So they were both on the same property, even though she was in the trailer and he was in the main house and she was in the trailer. Well, of course, she immediately stopped paying rents. And then she threatened legal action against him, claiming that her tenancy in this trailer was illegal. Well, my client served a 60-day notice on her to move, forgiving all the rent, I might add. But of course she didn't. And then we were hired. We filed a lawsuit on October 15th, 2018. She answered the lawsuit, contested the proceedings, and of course, demanded a jury trial with an attorney. And the case ultimately settled where not only was the rent waived, but my client gave her $3,000 for her to vacate as of December 1st, 2018. Let's move on. The third case was in the mid-2019, and that was on Latigo Canyon in Malibu. Now, a family, husband, wife, and children lived in a house, and they wanted to rent a room to Ellie Mae McNulty. Of course, they didn't know that she was a problem serial tenant. Well, she immediately stopped paying the rent, and my client didn't hire me to do the eviction. They hired another attorney. The matter went to court where there was an agreement. It's called a stipulated judgment, where she agreed to move by April 15th, 2020. And of course, all the rent was waived. Well, notwithstanding the fact that she signed a judgment, the judge signed the judgment, they gave up all the rent, she didn't move on April 15, 2020. And the other side of the coin was this was during the COVID time. So she claimed that it was a COVID issue why she wasn't moving, even though my clients at the time knew she had another place to move to. But there was an issue with the sheriff's office at that time, and they weren't even going to start commencing evictions until after May 31st, 2020. So, of course, she was supposed to move on April 15th. She refused to move on some phony COVID excuse. And then, of course, the sheriff wasn't going to be doing the lockout anyway. Now, it's one thing not to pay any rent and completely disavow all of your obligations, disavow the stipulated judgment, but that wasn't all she did. In the house with his family, she would be screaming and yelling and failing to keep her distance from other family members. But of course, this was COVID time. But in addition, this landlord had a daughter with immune deficiencies, and Ellie Mae refused to even keep her distance from her. Well, we were hired to file an emergency motion for an order demanding that the sheriff, notwithstanding their timetable of not doing an eviction until after June 1st of 2020, we filed an emergency order with the court and got a court order demanding that the tenant be immediately evicted. And of course, once we got that emergency order, the sheriff did do their job and evict this person. Could it continue? Oh my God, it continues. We next dealt with her in our fourth case in the year 2021. That was on Heathercliff Road. Now, my client, whose name was Alan Morin, he's a 65-year-old artist. He met Ellie Mae while strolling at the beach at Point Dume in Malibu. Now, My client was suffering from stage 4 melanoma and welcomed the company of this woman. Anyway, after a couple of meetings with her on the beach, she asked if she could stay in his house, his condominium, just for a few days until her place got ready. Well, she never left. And she unleashed a campaign of psychological terror that landed my client in the hospital. And when she was in the hospital, she changed the locks, preventing him from even entering his own house. Then she began to trash the place, flushing cloth napkins down the toilet, blocking the pipes, leaving feces in the toilet bowl in what appeared to be a show of spiteful deceit. Now, she then demanded of my client's family that they pay her $12,000 to vacate the premises. Well, my firm got involved at that point, and we filed an eviction based on a concept called a tenancy at will, because you see, she wasn't even a tenant. She never paid rent. It was just his good graces that allowed Ellie Mae McNulty to move into this property. Well, at the time when the lawsuit was filed, we also did something else. We filed a restraining order based on elder abuse and sought to get what they call a move-out order. Well, the court in that restraining order case granted our motion for a move-out order. We got that order, we delivered it to the sheriff, and Ellie Mae McNulty was evicted from this place. It continues. Fifth case, Pacific Coast Highway, February 14, 2024. She rented a room from one of my clients. She was paying a total of $288. And then, of course, she stopped paying. We served her with a 30-day notice. A lawsuit was filed, and maybe because when we served her with the lawsuit and she saw my name on it for the fifth time, she did vacate the premises before we even got a judgment against her. This is what landlords have to proceed with based on these types of cases. But you know, it's not just limited to an Ellie Mae McNulty. There are tons of serial tenants. I have in my career evicted a family whose last name is Yonko, Yonko, and spanning from the years 1997 through 2025, that's a total of 28 years, I have evicted people with the last name Yonko, a total of 34 cases. 34 cases. It is insane. We just finished up a case now where the tenant got locked out on May 16th, 2025. By the way, all my clients, when they talk about the Yonkos who we've evicted, they all describe them the same way, and that is that these people are gypsies. I don't really know what a gypsy is, but that's the way all my clients describe these people. So why does this happen? Why do tenants get to move from place to place and continue to damage the property, not pay rent, and rack up thousands of dollars of lost revenue for landlords? Well, it stems from a code section called CCP, Code of Civil Procedure 1161.2. So what does that code section deal with? For most eviction cases, the record is automatically and permanently sealed if a judgment is not entered in the landlord's favor within the first 60 days of the complaint being filed. The case can also be remained sealed if the tenant wins the case, or if the case is dismissed, or if there's a settlement where the parties agree to seal the record. Now, this law was based upon the intent where we would prevent tenants from being unfairly blacklisted by screening companies and future landlords for eviction cases. They didn't want to get them on a blacklist so that tenants would be unfairly blacklisted and no one would want to rent to them. Well, all these do-good laws are all abused by tenants, okay? And this law is totally bizarre. Why does it have to have a judgment within 60 days? If you get a legitimate judgment against a tenant in 70 days, why should that be sealed? It makes no sense to limit it to 60 days. I don't know on what basis anybody could limit it to just 60 days. And of course, these tenants file all kinds of delay tactics. So in most cases, it's impossible to get a judgment within the 60-day period. So I could understand if the tenant wins the case, or if the case is dismissed, or maybe even those cases where they agree to seal the record between the landlord and the tenant. But other than that, future landlords are sitting ducks, which allow these tenants to continue to prey upon landlords and move from place to place because they have impunity, because nobody knows that they were evicted again. I call upon the legislature to amend CCP 1161.2 so that if a judgment is obtained, regardless against a tenant, that record is not sealed, that future landlords can make intelligent decisions of whether to rent to these people. But there's also something else I'm suggesting to our California legislature, and that is tenants who are evicted multiple times should be legally classified as serial tenants. And once designated as a serial tenant, the tenant must first post funds with the court equaling the rent owed in order to contest the proceedings. So if they don't first post rent with the court, then they don't get a chance to contest the proceedings, which means that the landlord will have a free rein in evicting these tenants. It makes sense. They have something called a vexatious litigant, where people keep filing lawsuits and they get on this list, and then therefore those people cannot file a lawsuit unless they get court approval. Well, if you've got a tenant who's been evicted multiple times, we should designate that tenant as a serial tenant. And then if he's involved in another eviction case, he first has to post the rent money with the court, not with the landlord, with the court. And if he doesn't, then he doesn't have the right to contest the premises. Lastly, I call upon the city attorney's office for these municipalities to file charges, like misdemeanor charges. This is vandalism. This is theft. You know, they go after landlords if they don't take care of problems with their property, and they'll file lawsuits against them and charge them with misdemeanors. Well, you want to know something? If a tenant is damaging property and continually not paying the rent, that also should be a misdemeanor, and that also should be something filed upon by local city attorney's office. And that, my friends, constitutes our topic, which is serial tenants, rent thieves. We're now going to be opening it up to questions and answers. And we know that this is for informational purposes only. It is not a substitute for legal advice. If you do want to talk to me, electronically raise your hand. You'll see it in the toolbar. If you don't see it in the toolbar, go into a folder called reactions. It's probably in there. Also, this Zoom meeting is for general questions only. If you have a specific case with my office, God bless you. But we don't talk about specific cases. Please save that by calling me at the office, and I'll be there on Monday. And last but not least, if you are talking to me on the Zoom, please leave that camera open because it makes it much more enjoyable for everybody. And once again, you guys in YouTube land, thank you very much. Please hit that like button, subscribe to my channel. And if you do want to leave a comment, I promise you I will get to it. And now we're going to open it up. Our first caller of the day is Damon Mahaney. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hey, how are you?
I'm good. How are you?
I am good, thank you.
First, I want to thank you for all the time, effort, and all the information, valuable information that you provide us. And my question is, do I have to pay interest on the security deposit for my tenant who was living in my attached ADU in city of Los Angeles, which was newly built?
Okay, if it's an attached ADU, then now you're under the RSO, the Rent Stabilization Ordinance for the City of Los Angeles, and you do have to pay interest on security deposits. That's supposed to be paid yearly. And if you want to know what that rate is, if you go to my website, 103123.com. Click the button that's called Legal Issues, and you'll see the chart of all the interest rates that you have to pay from year to year.
Sure, I did, but the thing is, I think for this year, 2025, they changed the rate, and you mentioned it in one of your video that is, 4 point something, but before that it was point, I believe, point 52, 0.52. Am I right?
Right. The city council creates the rent percentage, the interest rate percentage each year. Incredulously, this year, I think they made it 4.3%, where in
Yeah,
years past, it was less than a percent. It was like 0.2. So
exactly. Yeah,
it's just insanity. You can't get 4.3% in most banks right now, but yet
right,
landlords who are facing all these losses and insurance and they're only giving us a 3% rent increase. How do they get a 4.3% rate for interest on security deposits? Again,
right.
it's insane.
Sure. Thank you. Appreciate it.
And thank you. We are moving on. Bear with me too. Sam, how are you?
Uh, Good, Dennis. Can you see me? Can you hear me?
I see you. I hear you.
Okay. I'm actually looking at 1161.2 A through A through 2. My question is this, in terms of preventing these serial tenants, isn't there a way that somehow they're and it's back in the 90s or 80s and 90s, there used to be a company called UD Registry Inc. operating out of the Valley, and they collected these UD records and made them available, I guess, before tri-merge and all these other things. Isn't there a way a landlord can find prospective landlord can go to the courthouse directly and somehow look at the litigation history of somebody, assuming let's say it's LA County and they've moved around. I know the story of Ellie Mae McNulty very well, and find out if this person has been sued in any, well, obviously that, but more important is the UDs.
And the
Um,
answer to that, Sam, is that no, you can't. In fact, even cases that I'm involved in, if I'm substituted out and another attorney comes in, I can't even look at that case. So these cases are hidden, and there's no basis of being able to view them under these public records. So the UD registry that you're referring to, they're out of business. And in most cases, these records become sealed. So I think one way to avoid these types of situations would be to ask for the last 6 months' rent payments to their quote current landlord. If they don't have a current landlord, I wouldn't rent to them.
yeah.
And I certainly wouldn't allow people just to move in like they did in that one case, my client Alton Marin, where she just he allowed her to move in without paying any rent. So ask for 6 months rent payments. That might cut it down, but it's very, very difficult. And landlords really need to arm themselves because these people are just marauders out there. They're truly thieves. They should be criminally prosecuted, but of course, we're landlords, so we don't get any help.
Yeah. Thank you.
And thank you, Sam. We're moving on to Rosanna Miani. How are you? Please unmute yourself.
Hello, is that better?
Much better, darling.
Okay. Anyway, had a situation come up and I thought I would ask the question, a general question. And this is where a landlord at sufferance, we're waiting for a tenant to vacate. They've said they were going to vacate. They've signed they were going to vacate. They uh, actually have an order to vacate, but as of September 6th, 11:59 p.m., no signs of movement in sight. So my landlord wants to know if she can go in and just take a look at the property. I advised her about the safety notice, 24-hour notice to inspect, and the tenant has refused. So where does this landlord stand?
Well, first of all, if the tenant refuses, then you could evict, but it appears that you've already filed an eviction case.
Oh,
Are you
yes,
just are you just waiting for the sheriff to do the lockout?
we are. And of course, they're behind in their paperwork. So it'll be as long as it's going to take, a month or two
What's
more, maybe.
what city, please?
Vista, California.
Vista. Okay, I didn't realize that. I know in LA County they were taking forever to do so, but I didn't know about even in San Diego County that they're still taking their time. No, you're just going to have to wait for the sheriff. It's as simple as that. You do have the right to go in to inspect smoke detectors or that type of stuff, but if she doesn't let you in, what are you going to do? You could bring forth an eviction case, but again, that's already been done.
Right. We're documenting that she tried to get it in just in case.
Yes.
That'll do it. That's pretty much what I told her. Thank you.
And I believe you're an attorney, aren't you?
I am. Yes.
I see that plaque behind you, and I can tell
Yes.
that that's from the state of California. Anyway, thank you very much. We are moving on to Richard Scott Lyle. How are you?
Let's see. Yeah, okay, I've unmuted. I have a question about one of the provisions in your model lease on your website, and I'll just quote the sentence. All items owed under this lease, except the security deposit, shall be deemed additional rent, unquote. And I have a hypothetical for you. Let's say the landlord serves a notice to cure covenant for some late fees and such, and brings an unlawful detainer. At trial, if the tenant argues that it should have been a 3-day notice to pay rent or quit, and secondly argues that the amount is below the rent threshold for City of LA, my question is, how would you argue against that? And number two, why do we want that sentence in the lease?
Right. And I might revisit that to have that in there. I put that in originally many years ago because sometimes landlords would include late charges into their 3-day notice. And technically, you're not allowed to put a late charge into a 3-day notice. So by having that phrase in there, if they had other charges, for example, maybe they were supposed to pay rent on a refrigerator or something, then we would still prevail. However, I think you're right that and I don't, people generally aren't going to catch it, but I might consider taking that out of my rental agreement because if you're asking for a late charge, then it would just be a notice to perform or quit. And there's so many more rules if it was a notice to pay rent or quit. So I'm in agreement with you, Richard.
Okay, thank you. I'm just trying to revise my rental agreements.
Yeah, I think I might be taking that phrase out. I put it in for one reason, but it might have some adverse effects. So good knowledge on your part. And we got, ladies and gentlemen, we got back-to-back attorneys because Richard, you're an attorney too, aren't you?
Yeah, I'm sort of out of California now. I just have the couple of rental properties left in LA, one of which is
You're smart. You got out of Dodge. Anyway, thank you very much. And we are going to go to Jim Polina. How are you?
There we go. There we go. Hey, Dennis, how's it going?
It's good, sir.
It's my very favorite part of Saturdays. Thank you much. So I got a question for you. I've heard you say a number of times in certain situations, you cannot evict the tenant, their daughter, their grandchildren, unless it's for cause. And I want to find out which areas of LA County or LA City, RSO, et cetera, does that apply to?
I think I need more information. Can
It's
you be more
just
specific?
there is nothing. It's just very in general. I want to. So what I do is I lend money, and if I have to foreclose, I don't want to foreclose on tenants I cannot evict.
Well, when you do a foreclosure, for example, if the previous owner, after the deed has been recorded, it's called the trustee's deed. Once that deed has been recorded, then you are allowed to serve a 3-day notice on any occupant in the property. So usually that would be the former owner or possibly the former owner's relatives, like children, for example. But if in fact that property was leased and that person has protection under the law, and if you were in a rent controlled area, you would have a lot of difficulty in evicting that quote tenant. Now, a lot of times they'll make it where the son will say, "Oh, I was renting from my father who now lost the property," and they try to claim tenants' rights. But usually we can get around that.
So if it is tenants, doesn't matter if it's LA County or LA City, RSO, that I'll
Well,
have
it matters.
difficulty.
Yeah, it matters if there's a rent control jurisdiction. Okay, so if it is rent control, then you're going to have a problem if in fact that person is a tenant. You're not going to just be able to serve a 3-day notice to quit.
So all of the above.
Yeah.
Oh gosh. All right. So I want to say to you, Dennis, and you've heard it before, you are an absolute hero and advocate for mom and pop landlord taxpayers. Keep the good fight going and keep the message going. I applaud you very much.
Thank you very much, Jim. I appreciate it. Moving along to another regular, Harold Rhodes. How are you today, sir?
Right, Dennis, can you hear me?
Perfectly.
Man, I'm so loving the show. And it's you kind of remind me of Rod Serling talking about all the negatives, but then you're like Jesus because you can save everybody. Not everybody, but you know what I mean. Okay, so I'm back to the same scenario. Like I'm getting closer to pressing the button to get it. I have a
I
owner.
figure when the show will be in like the 6th year, then
Then I'll get rid of him.
then that button will get pushed.
Well, no, I'm getting even closer. Okay, so basically, if as a owner move in, just cause City of LA, I just give the 60-day notice, no other forms, don't deal with the city. He gets his last month free. My question is, let's say that it's a 60-day window. The first part of the window, he would normally pay the rent, but I feel like if I do the 60-day, he might not pay his rent. So can I wait till he pays the rent and then the next day give the 60-day notice?
True, but then he'll still have 60 days to vacate from when you serve that notice. And if you stop paying the rent within that period.
Yeah, I guess you're right. That was stupid, but I'm glad you. Okay. One last thing, real quick. If he decides to stay and I have to evict him, is the timeline to evict him still really long? Like I told him, 4 months till he leaves.
About 3 to 4 months lately, yeah, unfortunately.
One last thing. What if they had a concierge service for the sheriff department? You pay him like $200 or $300 to get the person out immediately.
Suggest that to them, but I doubt.
Well, because buddy, would you pay the 300?
I'm sure my clients definitely would pay that to speed up the sheriff. The sheriff, unfortunately, and this is a conspiracy by the County Board of Supervisors to slow walk sheriffs' lockouts, and they're now taking 2 months and longer. Anyway, thank you very much, Harold. We're moving on to Scott's iPhone. How are you, sir? Scott, are you there? Ask you to unmute yourself, Scott. Scott is asleep at the wheel. We're going to move on to Mohammed. How are you?
Hello, sir. How are you? Thank you so much for your time. I have 3 small questions, but I go very fast, so I don't take your time too much. Can we put in the lease agreement that any maintenance issue is the tenant responsibility since everything is working properly?
Well, everything works properly until it doesn't. You know, I get these people in my office. They go, you know, my computer was working fine yesterday, but it's not working today. You know, things break. No, you can't really state that maintenance issues are now going to be moved to the responsibility of the tenant. No. Under the civil code, you as a landlord have to take care of those items. And so you should, quite frankly. And it's the tenant's obligation is not to damage the property, not to create disturbances, and of course, most importantly, to pay the damn rent.
Perfect. And another question, quick question. I have a lawsuit on my hand, habitability issue, and he says he was injured, and luckily you are part of it. If I send a drone and take picture from the sky that he's working inside and his leg has no problem, is that legal?
You own the property. I don't see a problem with, you're not going inside his unit. You're only taking it from above. So I don't see a problem with that.
Perfect. That's great. One last question. We have a lot of these. I have a lot of these cases where I have to chase tenants for rent. Can I give them a 30 days notice and start using this service called rent reporting? And
What was the last thing? It was a 30-day notice and use the what service?
the rent reporting that every month they report to the credit bureaus. If they paid, they said paid. If they didn't pay, they get the negative things on their
Yeah,
credit.
you can certainly report that to these credit institutions that the tenant didn't pay their rent timely. No problem.
They don't need to sign anything. I just give them a 30
No,
day.
just report it. Just like if you don't pay a mortgage payment, they could or a credit card payment, they could report you to the different bureaus.
Thank you so much, sir. God bless you.
Thank you, sir. Moving on to Albert. How are you?
Great, Dennis. Thank you very much. I was just wondering about the price gouging at October 31st. Is it on or they have again
Well, if our
pushed
moronic
it?
governor doesn't extend it, then it's over as of October 31st, which means that if your property is not subject to any rent control, then you are allowed to raise your rent to any level that you want, obviously market level. And that would, of course, include single family homes, townhouses, or condominiums. So on November 1, assuming the state of emergency isn't extended, I would be safe in telling all my clients, yeah, go serve your notice and you can go above 10%.
Thank you so much. I appreciate it.
And I see here somebody who just says iPhone. I'll ask you to unmute yourself.
Hi, Dennis. How are you today?
I am good, thank you.
Yes, Dennis. I have quite interesting situation here. I had a client, I mean, not a client, but a tenant that owed a huge amount of rent. And my plans was to put the security deposit towards, the back rent and what the damages that was caused by the unit, by the tenant. But it's quite interesting. The tenant filed for bankruptcy, Chapter 7, the day before he moved out. What do I do with the deposit since the court has pretty much, I guess,
Well, he's not getting back his deposit, so just you got 21 days to send a security deposit itemization. You already have that money in your hand. You're not giving it back, but you would be prevented from filing any kind of legal action to recover the additional rents owed to you based on that bankruptcy. You might want to check with the bankruptcy court because a lot of times these guys will file a bankruptcy to dissuade landlords and other creditors from continuing on, but then in a month or so, they just dismiss it. So I would keep checking by going to the bankruptcy court website.
because I spoke with someone and they said that um, maybe I can apply that security deposit. Like if the court discharges the back rent that was owed, what do I apply the security deposit towards when he technically doesn't owe any back rent anymore if it was discharged?
Yeah, but right now it's not
It's not
discharged.
discharged. Yeah, it's
So
not. Yeah.
serve your notice. You're not going to have any
I
problem.
can
You're
do that.
certainly not going to
Okay.
be forced to give that security deposit back.
Okay. And then one last question. On I have a 5 unit building and I wasn't paying attention when that security deposit law went into effect where we can only charge 1 month's rent. So I actually charged a little bit over 1 month's rent for one of my tenants or whatever, and I'm currently in the middle of an eviction case. Are they able to argue that I overcharged them on the security deposit? Like, would that make my notice defective?
I presume your property is under rent control.
Yes, it is.
It
Yes.
could be if they figured that out, then it could be because then what means is your notice is overstated because that extra money that you got had to be applied towards rent.
Yeah, because their attorney sent me something, discovery, and that was one of the questions on there. We're just about a month into the
When
case.
did the tenant when did the tenant move in?
The tenant the tenant moved in August, in August.
August
1st,
of 2024?
2025.
Oh, okay. Yeah, no, you weren't allowed to take more than 1 month's rent, unless you could say that that rent was used, that additional security deposit was used for some other damage or something that the tenant caused. So
So I just need to dismiss now since we're only 1 month into the case and just
if
start over.
if they know about it.
Yeah, they sent me discovery.
Okay.
And that's one of the things, the questions, I mean, the admissions on there or something or whatever. But okay, thank you so much.
And thank you. Moving on to Lynette Austin. Say hello. Lynette, are you there?
Yeah, hi there.
Hi.
So with it, with Rick Caruso's thinking of running for governor or mayor, would he be able, because he's the landlord, will he be able to help us
I
with
think you would have been
reversing?
I think it would have been tremendous help if he had won. I was a big supporter of
Right.
him, even though he lists himself as a Democrat, but at least he understands business. You know, I really believe that in most governmental positions, it's really good to have a businessman in there,
Yeah.
as opposed to having people in there that have never signed a paycheck, never created a business, and yet they're running the business of Los Angeles or running the business of the state of California. So I think he would certainly be of help because some of these ridiculous proposals, obviously as mayor, he would veto. So yeah, if he decides to run, he'd get my vote. I'll tell you that.
Yeah. And if he does run, can he reverse some of the stuff or?
No,
What
he
is-
would
what
need
is-
the cooperation of you know, the city council. You know,
or the supervisor, yeah, city
well,
council.
if he wouldn't be the supervisor if he ran
No,
for
it'd be city
100%.
council.
Yeah. I thank you very much, Lynette. We are moving on to, let's try with Scott's iPhone one more time. I'm going to ask you if you're around. And if you want to unmute yourself, this will be a good time. Okay, Scott, we love you. Moving on to Lucas Huerte Perez. I'm going to ask you to unmute yourself.
Yes, sir. I've got a little friend's problem that I wanted to ask about. Landlord, RSO property, Los Angeles, upstairs unit, another landlord. Their pipes burst into my friend's unit, who they're renting it out to. Unfortunately, water damage pretty extensive to the kitchen and bathroom. There's starting to be a mold issue. The tenant is threatening to file a lawsuit about habitability with the landlord. The upstairs neighbor is having arguments and problems with their insurance company. Our friend is trying to argue that it's upstairs neighbor's problem. Is it the landlord's problem, or is it upstairs neighbor's problem that they caused this leak down onto their tenant?
Is this a condominium?
It's a condominium, yes, sir.
Okay, so the landlord has the person below is a tenant, correct?
Yeah. Yes,
okay.
sir.
So he's only looking, his landlord has to take care of him. That's simple as that. So the landlord has charged with the requirement to get the place rehabilitated in the shortest amount of time that's possible. During that time period, if the tenant has to move out, then the landlord shouldn't be charging him rent for that period of time. Are we talking about the city of LA?
Yes, sir. City of LA.
And do you know if
Los
it's
Angeles.
built before 1979?
It isn't. It is a RSO property built before 1979.
Okay, so then if he's got to be out probably more than 30 days, then the landlord should be required to get what they call a tenant habitability plan, where he's going to have to be paid relocation money based on the RSO statute.
Absolutely what we're thinking. We just wanted to hear it from your mouth. Thank you.
I have one more question for you, Lucas.
Yes, sir.
How's law school?
It is fantastic. It's been rough. It's been hard, but I'm absolutely loving it. I've got, I think, another semester until I finish up my evidence class, and then I can do my externship with you, and I'm really looking forward to that.
And isn't your wife also either an attorney or in law school?
She's a 3L actually. She's working on the Eaton fire and the LA sex abuse foster care system comp program with McNicholas right now.
Oh, that sounds great. Well, anyway, good luck to you. Pass it on the first time, young sir. Okay, David, how are you?
Thank you, Dennis. Like always, thank you so much for everything. The question I have, if a past tenant of mine was evicted and now a new landlord checking references on this tenant, am I allowed to tell the landlord that he was evicted?
Absolutely. We
Okay,
got to
wait,
stick
wait.
together.
Now, if that is true, then why is it that landlords cannot form a forum of some sort and write down in some kind of an internet website that this tenant of mine was evicted? What is the problem?
Nothing prevents landlords from doing that. And I think the Apartment Owners Association has a setup where you can give them the names of the tenants who either skipped and not paid rent or was evicted. So I might want to check with them, but I think that's a wonderful idea.
And what if that they have AOA has also list of those people that had eviction sealed? Also, they have those.
No, they don't have those. If they're sealed, they're sealed. But that doesn't prevent a landlord with a sealed record from telling the world that this guy was evicted before. They just need to have a specific form so other landlords can easily check on it.
So we can basically form our own forum and reveal to the other landlords what's going on with this tenant.
Absolutely.
All right, then. Thank you. Yes.
And thank you, sir. Let's try Damon. I think you already talked to me, but I'll talk to you again. How are you?
Pretty good. Thank you for giving me another chance. So just got a question with the case, similar case that Locust, explained. So if we mention in the lease contract that the tenant has to provide the tenant's insurance, does the landlord still in charge of all the rehabilitation fees and everything, or just the repair for the house?
The problem with that is that this property is an RSO property under the rent stabilization ordinance. And under that ordinance, if the tenant has to be out for a substantial period of time, then the landlord is charged with getting a tenant habitability plan from the city and having to pay substantial relocation while the tenant is not there.
Wow. So what is it then, tenant, insurance?
Well, that's good, except if there's a law above it. I mean, you could put into your rental agreement that it's legal to commit a murder, but of course the law is going to be above that. So, but I certainly would recommend having that in your contract, that the tenant is charged with having renter's insurance, that not only does it cover that it covers any of the tenant's personal property that's damaged, but if the tenant has to temporarily relocate, that the tenant has to only seek compensation from his insurance company. I think that's a very good term to have in there. Anyway, thank you very much. And we are going to take one more call. I'm going to take Albert. Last call.
Thank you, Dennis. One question. So if I have a tenant which has been evicted and the file is sealed, wouldn't that in any way be a defamation thing that I say that all over the place?
I don't think so. I mean, the record
okay.
is sealed, but it didn't say that all parties were supposed to keep this confidential. It would have had to have said that.
Oh, so we have to check on that point then.
You got it.
I don't know what it says in there.
It's crazy. We know that. Anyway, ladies and gentlemen, I want to thank everybody for tuning in today on another edition of Zoom Landlord Tenant Talk Radio. We got a beautiful hot weekend. We got football. And you know what? I'll be back here next week with another edition. Have a great weekend, everybody.